Chapter 7 Void Agreements. According to Section 2, Clause G, an agreement not enforceable by law is said to be void. There are some agreements which have been expressly declared as void by Contract Act. Such agreements are void because law expressly declares them void. Void agreements. First, agreement by incompetent person. For example, minor, persons of unsound mind, and persons disqualified by law. Section 11. Second, agreements made under bilateral mistake as to material fact. Section 20. Third, agreements of which the consideration or the object is unlawful. Section 23. Fourth, agreements of which the consideration or the object is unlawful in part and cannot be separated from lawful part. Section 24. Fifth, agreements made without consideration with certain exceptions. Section 25. Sixth, agreement in restraint of marriage. Section 26. Seventh, agreements in restraint of trade. Section 27. Eighth, agreement in restraint of legal proceedings. Section 28. Ninth, agreements the meaning of which is uncertain. Section 29. 10th, agreements by way of wager, that is, wagering agreements. Section 30. 11th, agreements contingent on impossible event. Section 36. 12th, agreements to do impossible acts. Section 56. 13. Reciprocal promises to do things illegal. Section 57. Wagering agreements. According to Section 30 of the Indian Contract Act 1872, a wagering agreement is void under the Act. Wagering agreement is an agreement between two or more persons in which one person agrees to pay a certain sum of money or money's worth to another on happening or non-happening of some specific future uncertain event which is beyond the control of either parties. That means if that uncertain future event happens or not, in both the situations, one will win and the other one lose. Further, it should be noted that the parties have no interest in the happening or non-happening of the events other than winning or losing. Following are the exceptions. Following agreements or transactions are not wagers. First, commercial transactions. A commercial transaction which is done with an intention of delivering the goods, that is, commodity or security, and payment of price, it is not wager. If taking or receiving delivery is not an intention, it will be a speculation and will be void. Second, option dealings. Option means a right either to buy or sell or not. Option dealings are not wagering agreements and are not void. Third, authorized lotteries. A lottery is a wagering agreement. Therefore, an agreement to buy and sell lottery tickets is a wagering agreement. However, the government may authorize lotteries. Fourth, crossword puzzles or Kaun Banega Crorepati kind of competitions, where skill plays a significant role in the winning of a competition and awards are dependent upon the best skilled performance, is not wager. Fifth, chit fund schemes are not wagering agreements because sooner or later everyone gets what he required to pay over the period of the chit fund. Sixth, horse race. A subscription or contribution or an agreement to subscribe or contribute towards any plate prize of a sum exceeding 500 rupees or more to be awarded to the winners of the horse race is not unlawful. Seventh, contract of insurance. A contract of insurance is not a wager, rather it is a contingent contract.